as I'm drafting my complaint and preparing my brief in an action against the sheriff for redcoat warrants, I'm thinking that the flock camera, Motorola camera system operation will thereby be jeopardized and maybe slowed down dramatically if the court rules for the law. Now, my suit is one I've already filed against our sheriff in federal court in a case that under the U.S. District Court Judge McDonough here in Chattanooga went nowhere on account of, let's just say, judicial prejudice in the Sixth Circuit, and by him not able to see my grievance, not seeing an injury. The relief is going to have to come in state action where no federal issues are involved. And my demand that there be compliance with the Tennessee arrest warrant exceptions law will force a major redo of the sheriff's department, especially in the way that the deputies accost, seize, jail, and criminally charge people. The warrant requirement protects the deputy. Now, I sued Deputy Brandon Bennett in his personal capacity for his gun collection, his bank account, his house, his rugs, his pièce d'art on his walls, and everything else, because he was personally responsible for arresting me without a warrant and not having probable cause. And the reason this next case in circuit court or chancery has legs to stop the flock Motorola scam is that it will force the sheriff's department to solicit a warrant by drafting the criminal complaint before the seizure. Now, the seizures that we have in mind are misdemeanors, and the interpretation by the department of 47-103, that's 40-7-103, is that we can arrest anybody on the spot without a warrant. That's the policy. And the claim is, well, if it's happening in the officer's presence, that authorizes the seizure. And it doesn't, because there's a second test that has to be met. The second test is it a public offense? And so my brief, which I've already written, I've already submitted it in two different courts, two federal courts, is that the offense has to be in the nature of a breach of the peace. So the statute says the officer may make it a warrantless arrest for a public offense or a breach of the peace threatened. And effectively, a public offense is an actual de facto, de jure breach of the peace. That would be an affray, a riot, a drunken brawl, menace, threat, bellowing, making gestures that threaten other people and make other people in that immediate context feel uncertain about their personal safety and health and welfare. Therefore, the officer may make the arrest on the spot. An angry man swinging a bat around during a protest, for example, or a man inebriated walking out of a tavern and shouting at people and threatening them for looking at him, that kind of thing. These are public offenses arrestable on the spot without a warrant. But if it's a damaged taillight or driving on suspended that the officer happens to know about, it can't be arrestable even if the cop knows about it. He has to get the warrant first. He has to let his victim go and then go to the magistrate and swear out the complaint, which is to say draft the narrative which contains all the essential elements of the offense to secure notice to the defendant. All the elements have to be stated in the complaint. He gets the judge to sign it. The judge cannot help him write it, but the judge reviews it for sufficiency, and if it's sufficient on his testimony, he signs the warrant. Now the deputy has to go and find the person and make the arrest. That's a long and complicated process, intentionally so. That's what the law requires, and that's what my sheriff's department ignores.